recommendation of Ibrahim Bey. Ladies and gentlemen, I extend my deepest regards. As I was preparing my speech, I referred to 3 sources. One of them was the Medical Deontology Department at Cerrahpaşa. The second one was the Criminal Law Department of the School of Law. And I went to the 5th Expertise Department of the Forensic Medicine Institution. So I have, although it may seem theoretical, I have tried to gather all the information that's out there. Ethics has at its roots the actions of people. Not all activities of people, but those activities which focus on morality. It's a sub-branch of morals. There are 3 different manifestations of ethical behaviors, ethical approaches. One is normative ethics. That is the area where the general norms, values, and their importance are questioned. Practical ethics is the evaluation and assessment of these behaviors. There is non-normative ethics. If a subgroup of this, it's a subgroup of this group, it's a descriptive type of ethics which tries to describe and analyze these behaviors, and there's meta-ethics, and that could be regarded as a subgroup of non-normative ethics. Immoral means not abiding by moral codes. The theory of ethical right and wrong has got to do with values that arise at various times and usually contradict. Morals is the practice of ethics. It draws the framework for how ethical rules can be put into practice. Unethical means these are actions that are suitable to values but not suitable to reasoning. They cannot be deemed righteous. A moral is something that has got nothing to do with morals and cannot be perceived by ethical or moral values. When we talk about medical ethics and medical ethical training, we mean a discipline which analyzes the role of the values of the physician's relations with his or her patients, colleagues, and the society in general. Ethics is very widespread in all areas of our life, and one subgroup is prescription. Prescriptions have been written since antiquity, and they are regarded as medical documents. When the Turks first arrived at Anatolia, the prescriptions were written in Arabic, and in the Seljuks, the prescriptions started with the word, "May the patient take the following." Today, there's a difference in how these drugs are prescribed, and ethical problems should never be ignored as you're prescribing. There may be 4 different groups of issues: physician-patient relation, physician-pharmaceutical company relation, pharmacist-patient, pharmacist-physician relations are, and the pharmacist-pharmaceutical company relations. Here are some legal issues, legal topics, whereby physicians can be blamed in prescription behavior. Negligence, abuse of duty, fraudulent documents, causing death, corruption, bribery, and not abiding by confidentiality. In psychopharmacology, we see sometimes problems. The way the prescriptions are written may be against the purpose, and this can cause problems. In the execution of healthcare services, certain problems may arise that are the responsibility of both the administration of the hospital and the physician himself. Because the administration has healthcare services to provide, in this case, hospital services may be not organized well, or there could be errors, or there could be other responsibilities, such as the personal fault. This is a personal responsibility. This is a criminal and a civil responsibility of the physician. The physician prescribes, and if there is someone who's harmed by it, victimized by it, according to Article 41 of the law on debts, a person who has caused damage has to compensate for that damage, material or immaterial damage. In civil law, responsibility is not the natural consequence of crime, but of damage. There is the responsibility of tort. If responsibility may arise willingly or due to negligence, we never believe that this could be willingly done in the case of a physician, but there could be negligence or not being cautious, not being careful. If due to these reasons the patient's been harmed, and if there is disability, we look for someone in charge of it, someone responsible, and that is usually the physician. There can be a fault on the part of the physician, and that could be negligence. If an unwanted circumstance arises, we can talk about a fault. I just talked about responsibility for tort. I remember a few psychiatrists' files that were sent to the board. The physician asked another physician to intervene without seeing the excitability status of the patient, and the patient at the end of this process dies. And this is a tort. This is negligence because the first physician, did not really see the client but ordered intervention. There is also the responsibility of, or contractual responsibility. This is non-compliance with the responsibility, willingly or unwillingly, and in this case the physician is again to blame. There is also the responsibility of the physician in terms of criminal law. Again, a willing or unwilling behavior may be true here. We can be blamed, a physician can be blamed for deliberate action. That is, if the physician acts with a purpose that's different from treating or curing the patient. There's another responsibility of the physician that arises from making an error or fault. If professionals do not abide by rules and precautions, or if they're not competent enough, or if they don't show the necessary or due diligence, if they do not do all of these, there could be some practical consequences rather. And that's why we need to exercise extreme care, otherwise it would be regarded as an error. Let's say there's an error in your prescription. What could then happen? What could turn this into a fault? First, there is failure to take any precautions. A case has to be analyzed in detail, examined in detail. Blood and urine samples are taken. Not knowing all of these would fall under this group. Shall we give antipsychotics to a pregnant patient? If there's a problem, you can be charged with not taking any precautions. This isn't deliberate. This falls under the Turkish Penal Code. There are sanctions to it. Carelessness. Sometimes, due to carelessness, there could be disabilities arising. There could also be non-competence in the art or trade, or not abiding by the law. And here's a list of the laws we should abide by. The physician, of course, cannot know the flaws in the production of a medicine and cannot make a guess or come up with an opinion. So there isn't the responsibility of the physician. However, the physician should explain to the patient the side effects of the drug, how to use it. Furthermore, the physician is expected not to make any errors in writing the prescription. If this is not the case, there could be responsibility arising from a fault. There could be some harm due to medical treatment or intervention. There is usually a compensation case. Most of the time, the defendants are physicians, and the number of lawsuits are on an increase. There are two crimes, especially about the physicians working in the public sector. Say irtikap, please. İrtikap. If the person is economically or otherwise victimized, then this would be within the context of the public servant physicians. Furthermore, if the physician's medical assistance is faulty, then there could be a crime according to Article 85 or 89.
Abuse of profession. From 1 year to 3 years. A penalty from 1 year to 3 years. That is a sentencing, rather. This is Article 88. So very briefly. It's a cold topic. Well, in summary, distinguished colleagues, we could say that if the physician prescribes in an unethical manner, he's responsible with regard to civil code and penal code, and if there's any material damage, the physician pays for it. And with regard to administrative law, he may be prohibited from practicing his profession, be it as a result of negligence, be it carelessness. We may be accused for deliberate action even if we have not done so. There may be cases where we end up with a jail sentence. So please, let's get ourselves acquainted with the related laws and regulations of our profession. Thank you very much. If you have any questions. Thank you, dear.